Well, I think the Supreme Court needs to be more assertive. Today, I think, people say that the collegium system is opaque.
Yeah.
I think the government is far more opaque than the collegium system.
Are you saying that there is a perception today the Supreme Court is a weak institution?
Yeah, isn't it? So if the court is not going to decide it, if the court is not going to interpret the Constitution, then who is going to interpret the Constitution?
One of the most famous hotly debated transfers was that of Justice Muralidhar at the Delhi High Court.
Yeah.
How did you see that case?
Well, I think it's wrong. When I was in the collegium, I did not agree with the transfer.
Justice Lokur, let's start with what some might call the famous photograph and some might call the infamous photograph. An unprecedented press conference by judges of the Supreme Court, of which you were one. At that time, expressing in public, very unconventionally, your differences with the then Chief Justice. When you look back at that judges' press conference as it came to be called, do you regret that?
No, I don't. I don't regret it at all. No, not at all.
Take us back to that image, that moment. What was on your mind?
Yeah, you see, what had happened prior to that. You must appreciate that everybody believes in the Supreme Court that all judges are equal, right? Now, if some cases which are of importance or sensitive start going to a junior judge overlooking all the other judges, including the Chief Justice himself, they get marked to a comparatively junior judge. Then one begins to wonder what's happening. Why is this going on? Why is the Chief Justice overlooking himself? Why is he overlooking other senior judges? And we brought it to the notice of the Chief Justice, and he didn't seem to care about what was happening. And I think this is what eventually, it's not a decision that we took suddenly, it is something that had been building up, and we felt that, judges should not be overlooked. It's not a question of, some of us being overlooked. The four of us being overlooked, but it's just a question of judges being overlooked generally. And when that didn't seem to cut much ice, we thought we should make it public.
When you did decide to go public, was there a lot of debate that preceded it? Because it's quite unconventional, you would grant that. It's probably never happened before, probably never happen again.
Yes, but, we didn't debate it. We didn't debate or discuss it. We just felt that, people should know. Because it's not something that was happening within the court and, nobody outside knew it. People outside also knew it and they were wondering, what's going on. So, yeah, it's not that we debated the pros and cons of...
but you don't regret it?
I don't regret it.
You don't think it was a mistake? You don't think it set an unhealthy precedent?
No, I don't think so.
So the reason I ask is because this debate, the rostering of cases, which judge hears which case, this debate is still ongoing. Nothing seems to have changed in terms of the actual debate from that moment. And I think recently you yourself said if all judges are equal, then why is there so much fuss over who gets what?
Yes. Well, I still say all judges are equal. But, it's...
Do you believe there's a lack of transparency in how cases are allotted and listed?
I'm not sure whether there's, whether the system can be transparent in that sense,
Or a lack of a system?
There's a lack of a system,
Is it arbitrary?
It is. It's definitely arbitrary in the sense that, if all the cases go to a particular judge, why should that happen? Okay. Let me tell you, in the high courts, for example, where also we have the Chief Justice is the master of the roster. Now, the Chief Justice allocates the roster. He will say that 3 or 4 judges will deal with criminal appeals. 3 or 4 judges will deal with, say, tax matters, right? Normally, the Chief Justice and the senior most judge deal with public interest litigation. So that's fixed, So, but once in a while there might be a problem. Somebody might say that, listen, I don't want to do criminal cases. Okay, I don't want to do this particular kind of case, but it gets sorted out. I've not heard of a complaint like this. But fixing the roster, can be a problem. For example, you might recall Justice Sachar of the Delhi High Court. He writes in his autobiography that he was dealing with the cases arising out of the 1984 riots in Delhi. And, it appeared that the direction that he was taking was not very much in favor of the government. This was in December. And in January, the roster changed and the cases were taken away from his roster. He writes that in his autobiography. Why did that happen? Okay. And under whose instructions did it happen? It obviously happened under the instructions of the Chief Justice, who was the master of the roster. Okay. So in a situation like this, where the Chief Justice decides that, listen, I want a particular case to be heard by a particular judge, selectively, not that all criminal cases should be heard by a particular judge or all tax cases should be heard by a particular judge, but selectively this particular case should be heard by this particular judge, then it becomes a problem.
So this takes us right to, in a way, the huge public debate over how judges should be appointed, who should appoint them. And it's something that goes right back to a case that you were involved in. You were part of the bench that actually struck down the NJAC, right? The government at the time created a panel on which there were meant to be 6 people. And Parliament endorsed this. There was unprecedented political unity that this should happen, that the collegium system should be scrapped and there should be a 6-member panel and it would have representation of judges, but not exclusively so. You were part of the bench that actually scrapped this. And today that debate is very contemporary. And there was, for a moment, it looked like a full-blown confrontation between the Modi government and the judiciary over this issue. When you look back at that judgment and you subsequently see the functioning of the collegium, do you think that judgment was valid?
Yes. You see, first of all, none of us on the bench thought it as a confrontation. Okay. But the perception...
you were overturning a parliament law.
Yeah, that's okay. That's part of the game. This is not the first parliamentary law or the first constitutional amendment that has been set aside. So it's not a confrontation. No, the judiciary is not in confrontation with the executive. Let's be clear about that. Or in confrontation with parliament. But yes, as they say, the proof of the pudding is in the eating. Now, we felt that the law that was enacted, the constitutional amendment and the law that followed, would take away the independence of the judiciary.
Why did you feel that? Because the panel allowed for representation of the Chief Justice and 1 more judge. It's not that the judges would have no say in the appointment.
Yeah, right. But you see, there would be what is called eminent persons.
Right.
Okay. Now, whom do you decide is an eminent person? All right. What is the criteria for deciding an eminent person? There would be the law minister also. Okay. So it would be, 3 versus 3 kind of a situation. And then who takes the final decision? It's the government that takes the final decision. Today, as they say, the proof of the pudding lies in the eating. Today, it's the same thing.
How is it the same thing? Today, the collegium chooses the judges. But yes, the government
that's it.
Has to send the file back.
Correct. And the government can sit over the file, which it has.
Yes.
Been doing for a long time. Okay. So, if the NJAC had come, we would have been in the position that we are in today, perhaps in a slightly worse position.
So, do you think, though, since that judgment, or the bench of which you were a leading voice, the collegium has functioned as it ought to?
Well, I've been of the view that the collegium system needs some changes.
Like what?
One was that we felt that we should be in a position to meet the judges whom we are selecting. All right. Earlier, the system was that, you just look at the file and say yes or no. In all probability, say yes. But who is the person that you are selecting? Okay. There are sometimes views that are expressed by the government, which may not necessarily be correct. Okay. Do we just accept it, because the government says so?
Let's take Saurabh Kirpal, for example.
Yeah.
Just as an example, not to make it about him.
Yeah.
But that's a case where the government opposed his appointment.
Yeah.
The Supreme Court could assert itself again and just insist on it.
Yeah, it could. And I think it has, but the government has taken no action.
Right.
Okay.
So what happens then?
So what happens? That's the question. Okay. And this is the question which the NJAC did not answer. Today, I think, people say that the collegium system is opaque.
Yeah.
I think the government is far more opaque than the collegium system. You
In
don't
what
know.
manner? By simply dragging its feet on decision
By
making?
simply dragging its feet and by simply telling the Supreme Court something which, nobody knows. Okay. Recently there was this, I think some judge from Gujarat High Court.
Yeah.
From what I've read in the newspapers, I haven't seen the collegium resolutions. But what I've read in the newspapers is that the collegium said, Supreme Court collegium said, that we are deferring it for the time being and we send it back to the High Court, all right, to be placed again after some time. Was it sent to the High Court? We don't know. Okay, it appears that it was not sent because the file has to go through the Department of Justice. The Department of Justice sent a note saying that please now consider his case positively. Why? What was the reason? Why was it not sent to the High Court if it was not sent? What was the reason for the Department of Justice to say that consider it positively? The Supreme Court considers everything positively. I mean, they're not out to slash recommendations.
But by law, the Supreme Court has the power to insist after the file has come back once. The Supreme Court can insist, this is our choice, do the appointment. Or it can summon, I don't know, the law secretary for contempt of court. Or it can assert itself. Since you are a supporter of the collegium system, maybe with some reforms, some caveats, do you believe the Supreme Court has asserted itself sufficiently on the appointment of judges?
I don't think so. See, I can tell you about an incident that happened when Mr. Ravi Shankar Prasad was the law minister. I don't remember the details of what happened, okay, but there was some problem. And we thought that let's discuss it, with the law minister. So we requested him to come to the Supreme Court, and he came for a cup of tea. Before we could finish the cup of tea, the problem was resolved. Okay. So if there is a problem, I think the Chief Justice or the Collegium can sit with the law minister and say, what is the problem? Okay. Now, if the Collegium has a problem, the law minister will understand it. If the law minister has a problem, the Collegium will understand it.
Well, may not.
May not, but what's the harm in talking about it or discussing it?
But how do we know that they aren't talking about it?
Well, it doesn't appear to be so.
What concerns you when you say the Supreme Court has not sufficiently asserted its authority, its influence, even rapprochement to try and find consensus? What concerns you the most today in how judges' appointments are being handled?
Yeah, well, what concerns me is that the Supreme Court then turns out to be, in public perception, to be a weak institution. They can't get their way through. If you want to appoint somebody and the Supreme Court says, yes, we think he's a good person to be appointed, not only we in the Supreme Court, but the High Court has made that recommendation. Okay? The High Court Collegium has made that recommendation. The Chief Minister of the state has approved that recommendation. The Governor of the state has approved that recommendation. The Supreme Court Collegium has approved that recommendation. And yet, the government says, we're not going to appoint this person. Or we're not going to do anything about this person.
Yeah, they don't actually say we're not going to appoint always.
Yeah, but by doing nothing, the message is pretty clear. We're not going to appoint him.
Are you saying that there is a perception today because of how the collegium has handled the appointment of judges, some of the recommendations on which the government has just been silent? Are you saying that there is a perception today the Supreme Court is a weak institution?
Yeah, isn't it?
You tell me. If I say it, I'll be hauled up for contempt of court.
No. I don't think the Supreme Court will haul up anybody for contempt of court for this. But it's not asserting itself. Okay? I think I'm pretty
on
clear
the appointment of judges or on other matters?
On the appointment of judges. Yeah.
It's not asserting itself sufficiently.
Yeah.
Now, it's interesting that you make this point because a recent judgment led many people almost across the board to make the same comment. It has restored the faith in the judiciary. And I'm talking about the Bilkis Bano judgment that we just saw marching these released 11 convicts to jail with some very scathing observations of how that decision was taken. But the Supreme Court intervention in the Bilkis Bano case is also a review of its own judgment. And the Supreme Court, this bench made the point that the earlier judges were misled, they were not provided full information and so on. Do you believe the Supreme Court gave an easy pass to its own colleagues while making a judgment of, let's say in this case, the Gujarat government and so on?
Frankly, I don't know what you mean by an easy pass.
In the sense that while the Gujarat government the judgment said that this is an abuse of power, the Gujarat government has usurped powers, it has taken a decision that doesn't even belong in its jurisdiction. It explained the Supreme Court's earlier judgment on the case by alleging or by concluding that the bench had been misled.
Yeah.
So, do you think the bench previously had been misled?
Well, if the Supreme Court feels that way, I suppose they must be right.
Yeah.
But you can't, castigate other judges and say that, listen, you gave a wrong decision. People take different views. You have dissents, in a 5-judge bench, you may have 2 people taking one view, 3 people taking another view. Now, you can't say that, because these 2 people have not agreed with us, there's something wrong with them. That's not how the system works.
But when the verdict came, why do you think it had so many people to actually talk about our faith in the judiciary?
Yeah, you see, that's the problem. Now, the word you used was restore faith in the judiciary.
Yes.
What does that mean? Just think about it. It means that earlier there was a slightly, diminished faith, should I say?
Or it's debated.
Right? And it has been restored. Why? Because we had that faith earlier.
Yeah.
Okay. There was a decrease or a diminishing in that faith. And now it has again been restored. So that is the public perception.
Fali Nariman made the point in a conversation with me that when there are in the history of India's judiciary and executive, this is not particular to this government and this Supreme Court, I should clarify that. But he said, whenever there are very strong governments, courts have always been weaker. This is just the nature of how it is. Do you agree?
Yes, maybe no. I don't know. The perhaps the most important judgment in our history was Keshwanand Bharati's judgment. At that time, the government was not a weak government. So I don't know. Perhaps I don't want to debate that with him.
Let's talk about some of the recent very critical judgments that have come from the Supreme Court. Upholding the abrogation of 370 is, of course, top of the mind in some ways. You have been critical of the Supreme Court, and different people have picked up different aspects that they disagree with. Right? Some believe that the court sidestepped some questions. That how was a state actually demoted to a union territory? The Supreme Court didn't get involved in this question. There are others who have questioned whether a presidential notification is the legitimate start to a constitutional amendment and so on. Where do you think, because I know your position is that you believe the Supreme Court in some ways erred in that judgment. What for you is the central mistake according to you?
Well, I think the biggest mistake really was not deciding whether a state can be divided into two or more union territories. Now, to say that, listen, this is an issue that should have that we will decide in an appropriate case. I thought this was the most appropriate case. Okay, it's the first time it's happened, and if you don't decide it now, when are you going to decide it? When it happens again, assuming it happens again, are you going to say that, well, even this case is not appropriate, let's wait for a third occasion? So I think the Supreme Court, in that sense, made a mistake in not deciding this issue. Second is, the way in which Article 370 was dealt with. One of the things was that, did the Constituent Assembly say that it should be abrogated or should it not be abrogated? The fact of the matter is that the Constituent Assembly of Jammu and Kashmir did make a recommendation with regard to 370, which the Supreme Court said on an earlier occasion that this is an indication that it should not be abrogated. All right. So if that is the understanding,
the Supreme Court can change its mind. It's changed its mind in
but that was
decriminalization of homosexuality. It's changed its mind on Bilkis Bano.
No difficulty. But that was a decision taken by 5 judges. Right. So if the Supreme Court wanted to change its mind, it should have done so with a bench of 7 judges. Okay. They could not have just ignored it and said that, they may have said it. So I think these are some key issues that should have been dealt with. Well, the issue of sovereignty, for example. I don't think there was a need to discuss the issue of sovereignty, but the Supreme Court has dealt with pages and pages of sovereignty.
You've actually said that the judgment should have been shorter.
Yeah, it should have been shorter. I mean, if you take out the sovereignty issue, which I don't know why it was argued. But then the core question was that could 370 be taken out, right? That is one core question. The second core question was whether the state could be divided into union territories. Now, so far as the first question is concerned with, I don't think it was dealt with adequately.
On whether it's temporary or not?
Yeah. You see, the Constitution
refers to it as a temporary article.
Temporary, subject to what the Constituent Assembly says. Constituent Assembly of Jammu and Kashmir says. And the Constituent Assembly of Jammu and Kashmir gave a recommendation, which was accepted.
So basically, you're arguing that the approval of the Jammu and Kashmir Assembly should not have been bypassed.
Yeah, of the Jammu and Kashmir
original
Constituent Assembly should not have been bypassed, could not have been bypassed, because the Supreme Court on an earlier occasion had held it to be, and therefore...
But that effectively makes 370 permanent.
Yeah, effectively, yes.
But then the nomenclature calling it temporary is contradictory.
Yeah, that's okay. I mean, it was temporary until the Constituent Assembly gives a decision. And the Constituent Assembly gave a decision.
So you believe that the Supreme Court was erred on two counts.
Yeah.
One is that it didn't tackle the question of its previous verdict.
Yeah.
Which had held that the Jammu and Kashmir Constituent Assembly's approval on this issue was necessary. Yeah. The second, it didn't tackle the issue at all about a state being carved out into 2 or more union territories.
Yeah. So far as the first one is concerned, the Supreme Court kind of tackled it, but in my view, did not tackle it satisfactorily.
Okay. Now, you made this point about, the perception of the Supreme Court as a possibly weaker Supreme Court than before. And these things have happened in phases. It's not, like I said, there have been such moments and such debates before. The Supreme Court has in the past upheld the emergency, for example, right? So we've had these debates before. We've had these moments before. But isn't the real problem that there is an increasing appetite for A, vigilante justice, B, justice that is delivered actually by the executive. So, for example, if you look at the use of bulldozers today, right? You see bulldozers roll out. And by the way, you've had Congress-led states also now emulating what the BJP had begun. Bulldozers roll out theoretically to actually roll over illegal encroachments or illegal constructions, but almost always dealing with somebody who has committed a heinous crime or is accused of committing a heinous crime. And there's great public support for this, often for this. What do you make of this bulldozer-driven justice?
Yeah, I don't think this bulldozer-driven justice or bulldozer justice has anything to do with the weakness of the judiciary or the so-called weakness
or
of
just
the
how
judiciary.
long it takes for anybody to...
The problem really is the delays in the courts.
That's what I meant.
Yeah. So if a case is going to take so many years, well, somebody says, might as well, hand over justice myself, because I think what this person has done is wrong. Now, when you talk about the demolition of properties, what does the state say? Now, I'm not talking about any particular state, but I think all states say the same thing, that this was an illegal construction. Number one. Number two, this was an encroachment on public property. That's why we demolished it. All right. Which means that the state knew that this was an illegal construction and this was an encroachment. Why are they not taking any action when they come to know about it? Is it that they suddenly come to know about it when some incident happens? Okay, somebody throws a stone at a procession or something. Then they say, oh yeah, this thing is illegal, so let's demolish it. But if they knew it, why did they not take action earlier?
Yeah.
Okay, so you have this, what we in the legal profession call circumstantial evidence. That a certain event happens and there's a certain follow-up, action taken on the basis of that event.
Yeah.
Put two and two together and you find a correlation. So if somebody goes in a procession and somebody throws a stone at the procession and that person's property is demolished.
Which is what we've actually seen happen recently in Mira Road in Mumbai.
Right. So then you say that, well, the trigger for that was this incident. All right.
Yeah.
Now, how did the state come to know overnight that this was an encroachment or this was illegal construction? Did they know it? If they knew it, why were they silent? Okay. The law of the land requires that before you demolish something, you must issue notice.
Yeah.
All right. That person may say, all right, I'm sorry, I made a mistake. I'll demolish it myself. You don't have to take the trouble of sending a bulldozer. I'll do it myself. But that's not happening. That's why this expression bulldozer justice. So that's unfortunate.
The point is that politicians are being voted back into government on the basis of, among other things, this program, right?
Yeah.
So you have chief ministers who actually wear this approach as a badge of honor because they see it as an example of how tough and effective they are at containing law and order problems. And the truth is that there are many, many voters who agree with this.
Yes.
What does that make you feel as a judge?
Well, it's a rule of law issue.
Yeah.
The rule of law is being bypassed. Is that good? Okay. If the majority of the people in the country feel that the rule of law should be bypassed, we're heading for anarchy.
What do you feel? Because it's now a very mainstreamed instrument of state response.
Yeah. Well, it's not something that's happening on a daily basis.
No, not a daily basis, but it's not unusual. It's not rare anymore.
Yeah, but that's wrong. And I think the Supreme Court or the courts in the states, the high courts, should step in. We have all the constitutional courts, that is the high courts and the Supreme Court.
Do you believe the court should step in suo motu?
Yes. I was just going to come to that. Yeah,
Please elaborate.
We have this suo motu jurisdiction of the courts.
So
right?
You believe the courts, maybe the high courts of the particular state, any particular state where this is happening, should on their own step in and stop bulldozers as an instrument of state response to alleged crimes?
Yeah. You see, take a particular state, say state A.
Yeah. All
right. There have been 2 or 3 or 4 instances of bulldozer justice.
Yeah.
I think the court, the high court of that state A, can suo motu say that, listen, this thing has happened, 2, 3, 4 times. Why has it happened? We'd like to know. Because if you're going to do it again, there's going to be a problem. So let's have a look into this. And you tell us what happened and why did it happen.
And are you surprised that no court has thought of doing this?
Well, I'm disappointed. I'm not surprised, but I'm disappointed, yes.
And you believe that if this becomes a larger phenomena, you actually think that basically it's subverting principles of natural justice.
Yeah, principles of natural justice and the rule of law.
One of the big debates around court decision making. So there's backlog, there's a shortage of judges, it takes a very long time. But also is bail.
Yeah.
Right? Bail, which was considered which was considered as the norm or the preferable norm and not the exception, seems to have increasingly, at least at the lower courts, become the exception. By the time the case reaches the Supreme Court, normally the Supreme Court intervenes and grants bail. This is what we've seen in all manners of cases. But when you look at, I could rattle off any number of cases, politicians who've been arrested. There's the Aam Aadmi politicians who are in jail. You look at an Umar Khalid who has been accused of being seditious, who has not got bail. You look at Sudha Bhardwaj, who got bail after a long time. And I could quote many others. And the argument, of course, from a certain section of people would be that these are anti-nationals and so on. What do you make of the fact that bail is becoming not the norm at the lower courts or even at the high courts?
Yes, I think it's unfortunate, right? Refusing to grant bail is making the detention punitive.
Right.
That's not what is the intention of the law. Okay. That's why, bail and not jail. Now, the moment you convert it into something punitive, you're making a mistake. All right. That means you have already decided that this person is guilty. That's why I'm not giving him bail, and that's why he should remain in jail.
But isn't that the idea of prima facie guilt?
Well, prima facie guilt has been brought in this UAPA and PMLA and so on. Yeah. I'm not sure whether that's such a great idea. And I think the courts should look at it a little more, pragmatically. But in a normal case, why is bail denied to a person? Okay, the Supreme Court has said that in any number of judgments. High courts have said it in any number of judgments. That you look at the, whether this person is going to, tamper with the evidence or influence the witnesses or run away, that kind of stuff. In some cases, the gravity of the crime. Okay, that's fine. Now, when you look at it and the police says that, we want to have custody of this person, the courts should ask, do you have any material? In fact, the Supreme Court said that many, many years ago in the 1950s. Do you have any material to show that this person is going to tamper with the evidence or is going to influence the witnesses? If you don't, why should we believe you? Just because you say so. All right? In most of these cases, there is no evidence to show that this person is going to tamper with the evidence. Yet, the courts say that, there's a possibility that he might tamper with the evidence and so on. So therefore, let him remain in custody. That's not how the law is intended to work. You are right when you say that the district courts are reluctant to grant bail. I think the Chief Justice of India also said something to the same effect fairly recently. But
why do you think it's happening?
Why do you think it's happening? It's probably happening because, I don't know, maybe some kind of a fear, I don't know, that you might get transferred out, I don't know, really. But, transfer is one weapon which I think is should not be used.
The transfer is the collegium's decision, right?
Yeah, but at the level of the state, it's the decision of the full court.
I know, but I'm saying it's not that you see the high courts also being very bail friendly.
Yeah.
So it doesn't fully explain.
Correct.
Is there an imagined public approval that judges sometimes seek? I mean, judges are humans, right? Judges are not impervious to the zeitgeist of the time.
Yeah, you're right. I frankly, I am not in favor of transfer of judges.
In that, explain that.
Why should you transfer a judge from one state to another? Okay. The collegium says we are doing it in for the better administration of justice. Is there any evidence to show that because this person was there in a particular high court from which he or she has been transferred, the administration of justice suffered?
One of the most famous hotly debated transfers was that of Justice Muralidhar at the Delhi High Court. How did you see that case?
Well, I think it's wrong. When I was in the collegium, I did not agree with the transfer. And he got transferred.
Why do you think it happened?
Why do I think it happened? Well, I know why it happened, but I don't think I should speak about it.
He never eventually made it to the Supreme Court.
Yeah, which again is wrong.
Do you believe that he was too independent for his own good?
No, I mean, it's not a question of being too independent. I mean, he is an outstanding judge, right? The Supreme Court makes mistakes in sometimes not selecting the right person. Mr. Fali Nariman has spoken about another particular judge, Justice Paintsay of the Bombay High Court, who he believes should have been brought to the Supreme Court, but was not.
Yeah.
A mistake.
Yeah.
Right? I think Justice Muralidhar should have been brought to the Supreme Court. I think Justice Akhil Qureshi should have been brought to the Supreme Court. They have not been brought to the Supreme Court. It's a mistake.
So this brings us back a little bit to the collegium. You said in the beginning that the collegium, you don't believe the NJAC clearly was the answer, but the collegium needs to change. Yeah. What's the one thing you think you would recommend the collegium needs to change on?
Well, I think, they have to be more, objective in the sense that is this person a good judge? Generally, I mean, in terms of reputation, character, integrity.
That's subjective, right? You're asking for objectivity on what's a subjective interpretation.
Yeah, but then you see subjectivity by 5 persons.
Yeah.
I think it translates into objectivity. You can't have 5.
Yeah, but what's the change? What's the institutional change that would make the collegium more transparent? Or do you think it doesn't owe that transparency?
No, it certainly owes that transparency, but how are they going to do it? I think that's something for them to decide.
I want to come to another judgment that you were associated with at the High Court level, and that is on moves that are made by state governments from time to time to bring in a religious-driven quota. And you struck down the 4.5% sub-quota in Andhra Pradesh that you held was clearly based on religious lines. But the quota debate is back center stage, not just religious quotas, but quotas in general. And that entire idea of a cap on quotas is frankly out of the window. Let's start there. Why do you feel that if there can be caste-based quotas, some might ask, why can't there be religious-based quotas?
Well, religion-based quotas are prohibited by the Constitution. Yeah, so that was the basis of the judgment. I think the government has filed an appeal in the Supreme Court.
The state government?
I don't know, state government or government of India. I don't know.
I mean, the central would not, I don't think, would want a religion-based quota.
Yeah, but this was in 2012.
Yes. So you're saying the UPA government may have wanted one.
Yeah.
Right.
Yeah. So, again, now, the judgment was of 2012. We are 12 years down the line.
Yeah.
That issue has not been decided.
Yeah. That's pretty insane, right?
Yeah, exactly. That's the point,
But let's talk a little bit about this, because religion-based quotas, personally, I would not advocate. And you seem to suggest that you based it on the principle of the Constitution. But tomorrow the Constitution could change, another government comes in with an amendment.
You can't change
the basic structure.
Yeah. You're right.
And so we now come to the basic structure debate, which has also been now hotly debated. Who decides this basic structure? Why should the judges decide what the basic structure of the Constitution is? No less than the Vice President of India, a lawyer himself, has questioned this. What would you say?
Well, it is the judiciary which interprets the Constitution. Okay, that's, I think, accepted by everybody.
Yeah.
All right. So now, what is the basic structure of the Constitution, or whether legislation violates, a constitutional amendment violates the basic structure? Who is to interpret that? It's the judiciary, because that is the job of the judiciary.
Yeah, but who defines that basic structure? The judges have defined it, right?
Yeah.
It's not that the Constitution makers said, okay, we understand India could change 100 years from now, but these are the few things that can never change. They didn't say that, right? It is the court that is determining what the basic structure is. And that is what is being challenged by Vice President Dhankar and others, saying that the court cannot decide this. This is, you're infringing on the space of lawmakers.
Okay, so if the court is not going to decide it, if the court is not going to interpret the Constitution, then who is going to interpret the Constitution?
They would argue that the people, that they represent the will of the people, not the Supreme Court.
Yeah, but then they represent the will of the people means what? 40%, 30%?
So how do you determine what is in violation of basic structure?
Well, if something happens, there are enough indications. For example, you talk about, free speech.
Yeah.
All right, freedom of speech and expression. Now, if Parliament decides that from tomorrow onwards, we're going to take away Article 19(1)(a) of the Constitution, there will be no freedom of speech and expression. I don't think anybody will say that, this is not a violation of the basic structure.
Yeah.
It's pretty obvious. Okay. So our fundamental rights are a part of the basic structure.
Yeah, but sometimes your fundamental rights collide with, so for example, right to propagate your faith.
Yeah.
Tomorrow the Parliament can legislate on a uniform civil code, or even the Supreme Court could make an intervention on it. A petitioner could argue that this is interfering with my right to propagate my faith. We have seen some of these tensions, for example, in the Sabarimala judgment, where the Supreme Court is now reviewing its own judgment, like where a community will say, this is my faith, this is my custom. The Constitution gives me the fundamental right to profess, practice, and propagate this, right?
Yeah.
The counter argument will be the Constitution also allows for right to equality, and you have to have equality between people, between men and women. How do you resolve this tension? Let's pick up the Uniform Civil Code as an example.
Yeah. Okay. The Uniform Civil Code, I'm not sure that's a good example, because that's a part of the directive principles of state policy.
Yes. But that is the only basis in which it possibly can be challenged if it were to be legislated on, that it interferes with another fundamental right.
Maybe not. I don't know.
What is your own view on the UCC?
Yeah, I have not given it a thought, so I really can't answer that question. But you would have, something like, say, free and fair elections.
Yeah.
All right.
Yeah.
You would have federalism.
Yeah.
Okay. What constitutes federalism is a different aspect. What constitutes free and fair elections may be a different aspect. But the principle, independence of the judiciary, free and fair elections, federalism, these have been held to be the essential features of a democratic republic.
Yeah.
Okay. So if you take away free and fair elections, you are violating the basic structure of the Constitution. Now, you could argue, all right, again, it's for the courts to decide, that supposing you bring in some change in the method of casting your vote, for example, or electioneering, is that violating the principle of free and fair elections?
Yeah.
If the court says no, it's not violating the principle of free and fair elections, fine, it doesn't violate the basic structure. But if it does, then yes, it is violating the basic structure. So these are nuances that keep arising.
Yeah.
Okay.
But since you're talking about independence of institutions, not just of the judiciary, one of the big debates has been whether those who occupy constitutional positions should accept post-retirement appointments. And I can think of examples on the watches of both recent governments, both the Congress-led government and the BJP-led government, where for example, you've had a chief election commissioner entering government. That happened in the UPA time. You've had a former chief justice entering parliament, right? What do you think of that? What do you think of judges being in parliament?
Judges being in parliament, well, it's happened in the past, right? Again, what were the circumstances in which that person entered parliament? That becomes important. You have a very fair, independent-minded judge, Justice Hegde of the Supreme Court, one of those judges who resigned when he was superseded, entering parliament and becoming the speaker. Okay, nobody raised a finger. Why? Because he was a person who everybody knew was independent, fair, right, and could not be, molded in that sense. You have judges like Chief Justice Chakla, okay, a person with very high degree of, integrity and reputation, becoming a minister in the cabinet. All right, I think he became the High Commissioner to England. So it depends, under what circumstances and who that person is.
Would you take a seat in Parliament if you were offered one?
No, I don't think so. I'm not cut out for that sort of a thing.
Because?
I'm not cut out for that sort of a thing.
So, but you're saying you don't have a blanket agreement or a disagreement with the principle of it.
Yeah.
Because, Arun Jaitley in his time used to talk about a cooling off period. There used to be this idea of a cooling off period, a 2-year period, where anyone who's judge, an election commissioner should not go into a post-retirement post, especially if that is determined by the government.
Yeah.
Do you agree with that principle?
Yeah, well, I'm not sure how a cooling off period will make a difference. I mean, if a person is a person of integrity, right? Why should he wait for 2 years or 3 years?
But who decides this idea of integrity, right?
Yeah, this is for the person who's offering the assignment. Now, Justice Chakla, for example, the government offered him the assignment of a cabinet post.
Yeah.
Okay. I don't think there was a cooling off period. But nobody raised a finger. What about Justice Hegde? Nobody raised a finger. I mean, there are quite a few instances of this. But there are certain persons who've been appointed or elected in Parliament. Maybe after a cooling off period, I don't know. But then you still ask questions that how come this person was given a ticket?
Yeah. Let me ask you in the end, 2 questions in the end. Do you look back at any judgment of yours with regret? Sometimes, you feel that was a mistake. Is there such a judgment in your life?
No, I can't think of any. No.
Either because of lack of available information or because you've changed your mind about an issue?
No. I can't think of anything. No.
What is the one thing finally that you would want to see change in the Supreme Court?
That's a tough question. Well, I think the Supreme Court needs to be more assertive. That's it.
In general or at this moment or this Supreme Court?
In general.
In general.
Yeah. The Supreme Court was at one time called the People's Court. All right, because it was for the people. I don't think anybody would call it the People's Court today.
That's grim.
That's grim, yeah.
You feel that cynical or that pessimistic?
Not cynical, but not even pessimistic. I mean, the Supreme Court has, risen from the ashes, so to speak. I'm not pessimistic. I'm not cynical either. But that's why I think if the Supreme Court was a little more assertive, it would be good for all of us.
I remember you being described quite often as the people's judge, and the people's judge is today being today asking the Supreme Court to be the people's court. Thank you so much.
Thank you.
Thanks
Thanks a lot.
Thanks.